Welcome everyone, and thank you for being here today. I'm excited to introduce our presentation, which focuses on a fundamental principle from Islamic teachings about justice and proof. The title of our session is The Rights of Claimants and the Onus of Proof. Today, we'll explore how these principles guide fairness in claims and disputes. We'll look at a key hadith from Ibn Abbas, which emphasizes that the burden of proof lies with the person making a claim, and the oath is for the one denying it. Let's dive into this important topic together. Copyright 2026 by Continuous Learning Development. Today, we're exploring the definitions of plaintiff and defendant. In any dispute, there are generally two main parties involved. First, we have the claimant, often called the plaintiff, and second, the defendant. In Arabic, these are known as al-muddi and al-muddu alayhi, respectively. It's interesting to note that jurists have some differences of opinion about the exact meanings of these terms. There are essentially three main views on how to define them precisely. One key point to remember is that, in legal proceedings, the burden of proof typically lies with the plaintiff. This means it's the plaintiff's responsibility to provide sufficient evidence to support their claim. Understanding these roles is crucial, because they form the foundation of how disputes are approached and resolved in law. This ties into our overall theme of understanding legal responsibilities and procedural norms. Let's take a moment to understand this hadith and what it teaches us about the burden of proof. It clearly states that the burden of proof lies on the one making a claim. This makes sense because if someone is claiming something that isn't obvious or visible, they need to provide evidence to support their claim. In other words, if you're bringing a claim, it's your responsibility to prove it. The other party, on the other hand, is considered innocent or not responsible unless proven otherwise. This principle is a core legal maxim in Islam, emphasizing fairness and justice. When we talk about the burden of proof, it's about understanding who has to prove what. In this context, it's the claimant who must establish their case, and this idea helps maintain balance and fairness in legal disputes. So, as we see, this concept ties into the broader theme of justice in Islam, ensuring that accusations are supported by evidence and that innocence is presumed until proven guilty. Today, I want to focus on the key word used in this hadith, which is bayyinah. The translation often renders it as burden of proof, but the actual meaning of bayyinah is something that clarifies and makes a matter clear and evident. According to scholars like al-Bugha and Mistu, there's a consensus that bayyinah refers to witnesses. In fact, another hadith from Sahih Muslim illustrates this point clearly. It mentions a dispute over a well between two Muslims, and the Prophet, peace be upon him, instructs that the claimant must produce your two witnesses or his oath. This highlights how crucial witnesses are in Islamic law, people who were present and saw what happened, serving as proof that a claim is true. Witnesses play a vital role in the courts of Islam because they help establish the truth. Their testimony can be decisive in resolving disputes. Because of this importance, we'll discuss the topic of witnesses in some detail later. But at this point, I want to emphasize that the exact meaning of bayyinah will be revisited to see if it truly refers solely to witnesses or if there are other implications. Not everyone is qualified to be a witness. If just anyone's testimony were accepted, it would be very easy for fabricated or false stories to be presented in court. This would undermine the entire purpose of seeking the truth and protecting everyone's rights. That's why Islam has established specific criteria that someone must meet to be considered an acceptable witness. First, the witness must be sane and competent. This means they should have the mental capacity to understand what they are witnessing and the importance of their testimony. Usually, the witness should be an adult, although there are some scholarly opinions that allow children to testify in certain cases. The witness must also be a Muslim. Generally, non-Muslims are not accepted as witnesses, except in cases that involve non-Muslims themselves. Another key point is that the witness must have a sound memory. If someone is known to be forgetful, senile, or unable to recall past events accurately, their testimony would not be considered reliable. Equally important is that the witness upholds integrity and honesty. This means they should be a good Muslim, fulfilling their religious duties and avoiding actions that are clearly forbidden. Even if someone meets all these criteria, their testimony can still be rejected if there is a clear conflict of interest. For example, if the witness is closely related to one of the parties, is openly opposed to a party, or stands to gain from the outcome, their testimony would not be accepted. These criteria are in place to ensure that the testimony given in court is trustworthy, fair, and aligned with the pursuit of justice. Let's talk about the witness requirements in Islam. Unlike some legal systems, Islam does not require the same number of witnesses for every type of crime or transaction. Instead, the number of witnesses depends on how serious the matter is. For example, in cases of fornication or adultery, 4 men are needed to serve as witnesses to establish guilt. This high standard reflects the gravity of such accusations. The Quran clearly states, "And those who accuse chaste women and produce not 4 witnesses, flog them with 80 stripes and reject their testimony forever. They are the evildoers," which emphasizes the importance of strong evidence in such cases. Now, for other crimes like theft or alcohol consumption, which also have prescribed punishments, only 2 just and righteous men are required to testify. The Quran says, "And take as witness 2 just persons among you," highlighting that the burden of proof is slightly less for these crimes. Overall, these varying witness requirements show how Islam balances justice and seriousness, demanding strong evidence for more severe accusations while still maintaining fairness for less serious crimes. It's an essential part of understanding how justice is administered in Islamic law. Now, let's explore the role of female witnesses in Islamic law. In some situations, a woman's testimony alone is considered sufficient, especially when the matters involved are specific to women or require their direct experience. In other cases, her testimony might be regarded as equal to that of a man, while in some instances, it is considered to be only half as reliable. There are also cases where, according to certain scholars, a woman's testimony might not be accepted at all. The situations where only women's testimony is accepted are typically those concerning issues they are more familiar with. For example, matters related to menstruation, post-childbirth bleeding, and related health concerns fall into this category. Here, their testimony alone is deemed valid. Mamasani notes that all the schools of fiqh agree on this principle, though they differ slightly on how many female witnesses are needed in different cases. Similarly, when it comes to matters like breastfeeding, pregnancy, childbirth, or even a child's crying at birth, the Hanbali school accepts a woman's testimony on her own. An interesting example from the Prophet's time involves a woman who testified that she had breastfed both a husband and his wife, which led the Prophet to separate them, as recorded by al-Bukhari. So, understanding these nuances helps us appreciate how the role of female witnesses is viewed within Islamic law, especially in relation to the nature of the matter and the context of the testimony. It highlights both the recognition of women's knowledge in certain areas and the differentiated standards based on the situation. In some situations, the testimony of a woman is exactly equal to that of a man. This is especially true for what we now call expert testimony. For example, if a woman is a doctor and she testifies based on her knowledge and expertise, her testimony would be considered the same as that of a male doctor. Similarly, if a woman is a tailor and she testifies in court that a certain garment is not up to standard, her testimony would be accepted just as if a male tailor had given it. There are historical precedents for this approach, such as certain hadiths of the Prophet, peace be upon him, and actions of Umar ibn al-Khattab. The Hanafi school, for instance, accepts the testimony of one woman regarding the sighting of the moon for Ramadan because it's a religious matter, and one woman's report is sufficient. The Hanbali school and some Shafi scholars share this view as well. So the key point here is that, while in many cases, the testimony of women and men may differ, there are important exceptions, especially when it comes to expert knowledge or religious matters. This highlights a nuanced understanding of how female witnesses are regarded within Islamic jurisprudence, connecting to our overall discussion on gender roles and legal testimony. In some situations, the testimony of two women is considered to be equivalent to that of one man. This typically applies in areas where women usually have less experience than men, especially within an Islamic environment. One key category where this rule is applied is related to wealth, monetary matters, and financial transactions. There is a consensus that a woman's testimony is acceptable in these areas, but it is generally considered to be worth half of a man's testimony. This understanding is based on the verse from the Quran, which states that if two men are not available as witnesses, then one man and two women can serve as witnesses. This approach reflects the recognition of differences in experience and familiarity with financial matters, and it also highlights how Islamic law seeks to balance fairness and practicality in witness testimony. It's important to see how these rules fit within the broader context of the presentation, emphasizing the principles of justice and the specific considerations in different situations. Let's take a closer look at how a case is handled in court, which ties back to our overall theme of justice and legal procedures. When a case is presented to a judge, the first step is for the judge to listen carefully to the claim made by the plaintiff. Once the claim is clear, the judge then turns to the defendant to ask if he admits to the charges. Admitting to the charges is a very powerful position because it acts as one of the strongest proofs against the person. If the defendant admits to what he's accused of, he's essentially binding himself to that admission. This means that the case is usually decided in favor of the plaintiff because the defendant's own admission carries significant weight. But what happens if the defendant does not admit to the charges? Well, then the plaintiff must present proof to support his case. Generally, if the plaintiff provides enough evidence, the court will decide in his favor. However, it's important to remember that the defendant isn't without rights here. He has the opportunity to respond to the plaintiff's evidence, which is a crucial part of ensuring fairness in the process. And there's an interesting point about oaths here. If the defendant denies the allegation, he may be required to take an oath. This oath serves as a solemn promise to tell the truth, emphasizing that denying an allegation is a serious matter. Overall, this process highlights the importance of admissions, evidence, and the right to respond, all of which are fundamental to fair legal proceedings and justice. Let's now consider the importance of having well-structured laws. Laws must be put in place to prevent men from unjustly enforcing false claims against others. If we ignore the rules of evidence and proper procedure, chaos could ensue, with people claiming ownership over others, property and wealth without proper proof. The key principle here is that the burden of proof lies on the claimant. This means that if someone makes a claim that goes against what is apparently obvious or the current situation, it's their responsibility to provide evidence to support their claim. And if they are unable to do so, the defendant has a way to clear himself by making an oath to deny the charges or claims made against him. To summarize the Hadith, this teaches us the importance of fairness and justice in legal matters. It emphasizes that claims need to be supported by evidence, and if that evidence isn't available, the accused can defend himself through an oath. This principle aligns with the overall theme of justice and integrity in our dealings, reminding us of the importance of honesty and proper procedures in maintaining social order.